you're listening to She Shield, your one-stop pod for all things personal safety. I'm your host, Sophia, and my goal is to help educate women and men on concealed carry, martial arts, and all topics self-defense. This episode is brought to you by Big Tex Ordnance, your soon-to-be favorite retailer for all of your firearms needs. BTO believes in only selling high-quality gear for responsibly armed citizens, as well as providing pre- and post-sale support. BTO values firearms training and supports firearms instructors nationwide. They even pay for their own staff to train with high-level instructors to ensure that when you as the consumer reach out, you are taken care of. Today, we have Chet Palumbo on the show. I'm really excited for your perspective on the show today, Chet, so I'd love for you to introduce yourself.
Thanks so much, Sophia. Really happy to be here and an honor to be on your show. What I'll preface everything I'll say with, and it's kind of stupid, but I got to say it, is everything I say is not legal advice. It is just for educational and entertainment purposes. And if you have a specific legal question, please consult a licensed attorney in your state. But as you said, my name is Chet. I have been an attorney since 2010. I've practiced pretty much exclusively criminal law since then. I have been predominantly a defense attorney, but I did spend a few years as a prosecutor as well. So I've been on both sides of the courtroom, and I found that to be really helpful. I've done, I think the number's right at 45 jury trials as lead counsel. So I do have a lot of trial experience and take a lot of my perspective from the experience of actually seeing cases from inception all the way to trial decisions and then talking to juries after that. And so that's my legal background. And then on the tactical side, where I try to bring perspectives on my YouTube channel, The Combative Lawyer, is integrating my, I guess about 11 or 12 years of experience in martial arts. I started Brazilian Jiu-Jitsu in 2011. I'm currently a 3-stripe purple belt. I'm also a green belt in combatives under Matt Larson. I've cross-trained in kickboxing and MMA. And as far as combative specifically, spent a good amount of time training with Ben Aubin of Red Beard Combatives. I have trained with Craig Douglas, Guy Schnitzler, Paul Sharp, and just really try to bring that combination of perspectives to what I do.
That's wonderful. Yes. And you are speaking at the Combatives Association Summit in September, correct?
Yeah, absolutely. Really, really excited about that.
That's wonderful. Do you have any ideas on what you plan on lecturing about, or is that something you're even comfortable talking about?
Oh, yeah, sure. No, it's about an hour and a half, 2-hour slot where I'm going to cover high-level overview of the law of self-defense and then really try to delve deep on some combative-specific issues and the law as it relates to combatives, both in how we train and how we make decision-making process or perform our decision-making process. And then along the way, try to debunk some common myths or misconceptions that are prevalent in the self-defense world.
That is incredible. I feel like we're getting a sneak peek today.
Yeah, absolutely.
Yes. For anyone who doesn't know about the Combatives Association Summit, it's a 3-day summit going on in September with 17, correct?
I think it's 17, yeah.
17 of, I would say, like the nation's leaders in self-defense, especially with firearms. And then, of course, I know there are people there that are teaching knife defense and even like, is it slapjacks? And
yeah, Guy is doing saps and jacks and yeah.
Saps and jacks. Yes, slapjacks. Sorry. I didn't know.
It sounds like a cereal, but
yes, it does. When he came on the episode, that was the first time I'd heard of them. So I was like trying to, yes. Okay. That makes a lot of sense. I should probably know since I'm going, but
no, that's okay.
Yes, for anyone interested, hopefully there are spots left, and I will link it in the show notes. So if you like the episode today, you can get more of it in September in Florida. So kind of exciting. All right. Well, I'm really excited for your perspective. This is something we have not had on the podcast yet. And I was thankful that Kristen brought your name up and recommended this topic because I feel like kind of the fancier side of guns is what is shown mostly on social media and even just self-defense in general, but actually inflicting harm, whether or not, it's kind of in response to an attack or not, is something that everyone should consider. And honestly, the first time I'd ever heard of anything legally to do with concealed carry, I hadn't even considered it before, was at my first concealed carry licensing class. Some individual from one of the insurance companies, I learned there's a difference, which we're going to talk about today, came up and kind of gave us his pitch on insurance for concealed carry. So that was the first I heard of it. You know, he told us enough stories where I felt paranoid enough to sign up, and I got my first policy, and I've re-signed with a different company recently, but we're going to talk about that today because listener, if you're someone who concealed carries, or even just like, honestly, is just a civilian, which even if you don't carry a weapon, this information is going to be really important for you. So, all right. So my first question for you, and this is probably a long-winded question, so I would love for you to just break it up however you would like to. Sure. But as far as the legal considerations someone should have for using force in a self-defense situation, what should they consider, one, and how would that compare ranging from hand-to-hand combat to something like use of a lethal weapon like a gun?
Yeah. That's a really good question. And I think the first thing a person needs to do is understand the definition of deadly force. It is something that's very commonly misunderstood, and understanding. And once again, this is where I'll say that it's pretty uniform across all 50 states, but make sure to the extent you can, reference your specific state's definition for the nuance. But in general, and I feel comfortable saying this in pretty much all 50 states, that the definition of deadly force is that force intended or likely to cause death or serious bodily injury or great bodily harm. Serious bodily injury, great bodily harm are pretty much the two terms that are used throughout the jurisdictions. And the death is the easy one. The more difficult one is understanding what is great bodily harm, what is serious bodily injury, and also understanding that threatening great bodily harm or threatening serious bodily injury also is considered in most jurisdictions the use of deadly force. So where does the misconception come in? It typically comes in, what I see the most is, and I've heard of a story of a person felt uncomfortable or nervous, so they pulled out their gun and they pointed it at the person to try to scare them off or whatever. And in their mind, well, I didn't use deadly force because I didn't shoot them or something like that. Well, in the eyes of the law, you pulling out a gun and pointing it at someone is the use or threatened use of deadly force. So if you were not justified in using deadly force in that situation, you have no right to pull out your gun and point it at them. If that person were to respond to you with using deadly force, you would actually be the bad guy in that situation. They would actually be justified in defending themselves from you. So understanding where that line is, and when you cross that line, you cannot cross that line of deadly force until that threshold is met. Another thing is, a lot of people think knives are a less than lethal option. Oh, well, I pulled the knife and I just, I stabbed him in the arm or their leg or whatever. I wasn't trying to kill him. I was doing that because, I felt threatened or whatever. Okay, that's fine. But you need to understand that cutting someone with a knife, stabbing someone with a knife is going to be seen 99 times out of 100. I feel comfortable saying 999 times out of 1,000 in most jurisdictions as deadly force. So like what we say is, if you're not justified in shooting them in the head, you're not justified in shooting them in the pinky or the toe or even pointing your gun at them. So try not to give too long-winded of an answer, but that first threshold being for people that want to carry a weapon is understand when that threshold of deadly force kicks in.
Absolutely. That makes a lot of sense. Where would you say that threshold normally is? Is that something you even feel comfortable commenting on? Okay. Yeah.
So it is when you are in fear of death or serious bodily injury yourself.
Right. Okay.
And then in some jurisdictions, when a forcible felony is being perpetrated against you, so typically kidnapping, rape, arson, that sort of thing. If, this is the She Shield. So we're talking about, women's self-defense perspective and everything. So definitely want the viewers to know that if a person's committing a violent sexual battery against you, just because they're not trying to kill you with a knife or gun, that doesn't mean you're not justified in using deadly force to stop that. So Same thing with a kidnapping. Someone's trying to kidnap your child and they're in the process of kidnapping your child. Once again, this is getting into more state specific stuff. So I feel comfortable saying in Florida and in, I'd say, most jurisdictions I've practiced in, but if someone's in the process of kidnapping your child, just because there's no knife or gun involved, it doesn't mean you're not justified in using deadly force. So with that, I definitely want to give the caveat and make sure you understand your state law, but the default where it's pretty much always going to be justified is where you are in reasonable fear of death or serious bodily injury. And there is an objective and a subjective component to that. Subjective, meaning you yourself were actually in fear of death or serious bodily injury. Objective means a reasonable person in your shoes would have been in fear of death or serious bodily injury. Both of those components must be present in order for it to be a justifiable use of force.
Absolutely. Your answers are so well articulated.
Oh, thank you
so much.
That's my job. Yeah.
Yes. Oh, absolutely. So my mother is an attorney, and
oh, nice.
Plus she sounds when she explains anything, like even the grocery list. she always thinks about what she says before she speaks, and it's quite lovely. I should probably do the same, but just kidding. So if someone wants to research their state laws, where do you recommend they go?
It's a great question. That's a really good question. Obviously, most people don't have the money to just call up their local criminal defense attorney and say, hey, can I book a 1 or 2 hour consultation with you and just pick your brain? As weird as that sounds, most people don't do that, but I know myself, I'd have no problem with that. If somebody were to say, and honestly, the hourly rate would be less than what they would charge for an actual case if they're just giving informational, it's just like an informational conversation. So if that's something, if you've got a few $100s and you're really interested, that's something that, is an option. Barring that, starting with your state statute on self-defense and just reading the state statute, and then going and finding your state's jury instructions. Most states have model jury instructions. I would say, so South Carolina is one of the few states that does not have model jury instructions, but almost all states have jury instructions. And what I tell people is the jury instructions are the most underutilized form of information regarding what the law is, because the jury instructions are what the jury will actually be read at the end of your case before going back to the deliberation room. So how beneficial would it be for you to know exactly what the jury's going to be told in terms of how to decide your case? Understanding the statute gives you the context. So the jury instructions reflect the statute. So you read the statute, you get a general understanding of what the statute says. Then you go in and you read the jury instructions and you say, okay, this is exactly how they're going to be instructed to decide the case. Only then would I consider reading cases. A lot of people make the mistake of they have no understanding of anything. They go on Google and they start looking for cases. You kind of have to be trained on how to read and interpret a case. So I've seen a lot of people read a case and then come tell me what the law is in their state. Oh, well, in this state, we can do this because of this case. And I look at the case and I'm like, that's not really what they were talking about in that particular case. So you're kind of putting the cart before the horse if you read a case, but you don't know what the statute is and you don't know what the jury instructions say.
That makes sense. Yes. I don't know why the idea of WebMD just popped into my mind when people
That's exactly it.
Kind of read.
That's exactly it. Yeah.
No, that's good to know. And okay, so when it comes to, first of all, that was incredible. I've never heard that. So I'm already excited to look that up in Arkansas, where I live. So, as far as it would be the defendant, correct? Someone who had to pull their firearm in this case in self-defense would be the defendant. Okay. Yep. So how important is it that the defendant has previous training in things like not only concealed carry licensure, but also like tactics classes, and even those specifically that go over soft skills, verbal de-escalation, kind of like Craig Douglas's courses? How important is that?
I think it's really important. And for people, and I'm actually going to talk about this at the summit, but
wonderful.
The muck aspect of managing unknown contacts portion of the ShivWorks courses are very important, simply because what I like about it from a lawyer's perspective is it gives you the ability to articulate why you did what you did. And if you were to say, I pulled out my taser, or I stabbed the guy, or I shot the guy because he just looked really sketchy and he came towards me, you're going to have a hard time with that, because what does that mean to be looking sketchy, right? We can start getting into a lot of, racial bias and racial prejudice if that presents itself and it's just someone looks sketchy, as opposed to being able to articulate pre-attack indicators and pre-attack clues. Specifically, I saw a definitive weight shift. I saw him clench his fist. I saw a grooming movement, and then articulate that based on your training and experience, which we hear police officers say from the stand all the time, but it's the same thing. Based on my training and experience, I observed these multiple pre-attack indicators. And then another thing I like about Muck is it teaches you to arc off the line, from where the person is coming towards you. That arcing not only has a huge tactical benefit, but by changing the angle of onset from where the person comes towards you, it allows you to articulate that even when you arced and came to the side, that person then reoriented themselves and came towards you. It gives you an additional ability to articulate that that's why I believe this person was not just going to walk past me, but was actually orienting themselves to continue aggressing towards me. So this training, while it tactically helps you tremendously, it also gives you the ability to articulate the entirety of this encounter.
Wow. I always say wow at least a few times on shows because these are just such incredible points. Yes, so managing unknown contacts is something I've probably mentioned almost in every episode because I feel like it's worth kind of working into the mind of the listener, especially because I don't know who's listening, if it's their only episode they listen to. So if that's something you've heard up until now, I'm sure this is the first time this has been discussed, the legal side of it, at least. And yes, I appreciate that so much.
Sure.
Oh my goodness. So as far as how someone should keep tabs on their training in case they were in a situation like this, is there any formal way to do this, like getting almost a certificate from each class and kind of compiling them if you had to present them in a court case, or is it just your word that you bring?
Yeah, you don't need to document it. I mean, if you want to, that's fine, but I don't see that as having really any huge benefit if you were to have to take the stand and articulate it. Just that you testify. I've had various self-defense training and that sort of thing, and we learned X, Y, and Z, and this is what I observed. So I don't think it's too important to document it.
That's good to know. I've been told that before, and I haven't done that. So I was just wondering if maybe in your experience, you've seen someone present that and it's helped in a case. So
the only reason you'd have to document it is if the prosecution disputed that you've actually had the training. And I don't really understand why, because that training can be a double-edged sword, right? That training can also be, oh, well, you're this super ninja Delta Force SEAL Team 9 person. Like you could have just done a death punch to their, whatever, a prosecutor could try to use that training against you. So strategically and tactically, I don't really see a reason why a prosecutor would be like, no, I don't think you've actually attended this muck training that you claim to attend. And if they did bring that up, I mean, you could offer what's called rebuttal evidence, to then show that I don't think that's a big deal, honestly.
That's good to know. Okay.
Yeah.
Wonderful. So how also would you say this type of situation would compare for a woman versus a man? And the reason I want to bring this up is when I posted the recording of my sim at ECQC, Craig had instructed, he put me with two pretty tall, big dudes. I'm pretty tall and muscular myself. So I appreciated that he tried to match me with someone who would kind of be threatening in the situation. But anyway, for those of you who do not know, Craig will give the participants a scenario, and then he will see how the one of the participants will react to that scenario, and that person does not know what Craig has told them. So I was the person who was reacting. I probably could have said that a lot better, but one of the guys was told to come at me, and like I think he had said his car broke down and he needed some help, and he was getting really close to me, like almost like right in front of me. So I was like, "Hey man, I'm gonna need you to back up, keep your distance a bit." And of course I'm arcing, and then he lunged at me and like smacked me across my helmet. And this was after I told him to back off, and I'd used my voice. I really did use my voice. And he'd smacked me a few times, and all I had is my gun, right? This isn't a situation. The sim, you don't have your pepper spray, and like, I don't know. There's like, it's really just about situations where you might consider drawing from concealment. And I drew from concealment. I pointed in. Of course, I drew, and as I gained distance, I pointed in. And then as he started backing away, I took it to a low ready. And then he instructed another guy to come in and then beat that guy up. So that's not really important to that part. But if you want to see that video, go to my Instagram. But I had some people comment and say, this is definitely not a situation where she would need to pull her gun. I had some warriors in the comments, and Craig commented back and said, for a woman in this situation who would be considerably alone and isolated, this is a proper response. And I agreed. Like the way he said it was, of course, way more articulated than that. But what would you say to maybe that scenario if you just want to go into generals with men and women?
Yeah, no, that's really good. And without seeing that video, I can visualize what happened. And, you know, I agree with Craig's analysis on that. I would have given the same feedback. With deadly force, it's always difficult when the person attacking is unarmed. People need to understand that fists and hands and feet kill more people every year than firearms. And so punching and kicking and choking can absolutely be considered deadly force. Once again, kind of going back to that initial statement of what's deadly force, you have to ask yourself, is what they're doing intended or likely to cause death or serious bodily injury? So what's serious bodily injury? It's injury that is likely to cause permanent disfigurement, loss of protracted loss of a bodily system, broken bones, severe lacerations, anything like that. Mere bruising is not considered serious bodily injury in pretty much all jurisdictions, but you know, things that it's a definition that is, you know, you kind of know it when you see it. When they try to give a definition, it's never an exhaustive list, but punching someone in the face repeatedly over and over again, pretty much always considered deadly force. And I did a video on this topic, and I think this is a good time to bring this up. It's understanding the difference between escalation and ambush. An escalation, it's two people that have a disagreement and it becomes physical, and maybe it starts with pushing, shoving, posturing, and then one person swings a punch. In an escalation situation, it's going to be a little bit harder to justify an immediate response to deadly force with just a single punch. Contrast that with an ambush, which I would argue your situation was more akin to an ambush. Person comes out of the blue. You don't have any sort of dealing with that person. There's no, you know, relationship or whatever. They're coming at you and they're hitting you. What possible reason does that person have to put their hands on you other than to cause serious bodily injury or to commit some type of forcible felony against you? And that, I would argue, makes your belief that deadly force is justified objectively reasonable. You know, in the situation that the example I gave was like I'm in some sort of argument with someone at a cookout or a family gathering, and he gets posturing, shoving, slapping. He decides to punch me. Well, I can't just pull my gun and shoot him at that point. I think that I have an obligation to try to de-escalate. I think I have an obligation to try to go hands-on. And it's only if And unless he gets on top of me, fully mounted, throwing unrestrained punches to my face, am I now in a situation where okay, well, this is deadly force. Whereas I'm at a parking lot and some guy comes out of the corner asking for change. And I'm like, no, man, I'm good. Hey, go ahead and stand back. And then he runs at me and starts punching me. That's an ambush. And I think you can go to deadly force quicker in that situation, just like in your situation. And the thing that the jury instructions will tell you in pretty much all jurisdictions is you are allowed to consider the relative physical size and capability of the parties in determining whether or not force was reasonable. And, I know we're in 2023, but females tend to be less physically powerful and strong than males. So a male attacking a female, there's already going to be presumptively a slight disparity in physical strength and ability. So no, I hope that answers the question, but I do agree with what Craig said, and I echo his comments on that.
Absolutely. It does make sense. And no, your comment about female and male anatomy is totally fine. And while I do believe in women's rights, I'm still I have my master's in exercise science, kinesiology, and that was a big topic, how the female and male bodies compared, and the literature is up to date and the data is up to date. So no, that you're absolutely right, and I think that should be considered in a court case. So no, that's totally fine. Comments like that are fine. If anyone disagrees with that, I feel like it's out of ignorance, in my opinion. So it's funny. I mentioned this because almost every guest speaker that's come on, a lot of them have been from the summit. You would think I'm sponsored and trying to get people to sign up. I'm really actually at first I was trying to sign up before people did. So, but there are still slots left. So hopefully if you're listening, you want to go, you can. Anyway, that's been discussed on the episode. And every time someone will say a little disclaimer, yes, women can be really strong, but, and I'm always no, you're okay. You can say that. So I appreciate you. So as far as, and I know I'm kind of just going from scenario to scenario, I do have some other questions written, but I'm really curious about this. So say a woman is in trouble and a man or a woman sees this and incorporates themselves into the situation. What would that look like in a court case, and what should someone consider?
So you're talking about going and assisting a third party?
Correct.
Okay. It's very important to know whether you are in a reasonable mistake jurisdiction or a, what's the other one? Alter ego jurisdiction. And what I mean is there are certain, so Florida, for example, is a reasonable mistake jurisdiction. What that means is if you are at Walmart and you see someone on top of another person just pounding away at them, and you think, oh my goodness, they're going to kill this person, this poor person on the bottom, I need to help them, and you pull out your gun and shoot the person. If it turns out that the guy on the bottom was actually robbing the other person at knife point and still had the knife in the other hand that you couldn't see and was trying to stab the person, you could at least attempt to make the argument that I was reasonably in belief that this person on top was not justified and my mistake was reasonable. Now, I'm not saying that there's not going to be an argument, on the other side, but you can at least make the argument. An alter ego jurisdiction says you stand in the shoes of the person you're trying to help. And if the person you're trying to help would not have been justified, then you're not justified. And it doesn't matter how reasonable your perspective is. So the advice that I give to people is to play it safe. I would almost never use deadly force to help a third party that's not an immediate family member of mine unless I saw the entire situation unfold. Because you could have the best intentions in the world and, it looks to you like, oh my goodness, this person is, now look, sometimes it may be completely obvious, it's a 24-year-old guy on steroids and everything, and he's pummeling a 95-year-old grandma in the park. There's certain things that are just so, but if you see two people just going at it, I would be very, very slow to intervene with deadly force in that situation. Once again, unless you saw how that situation started.
Absolutely. Okay. That's a great piece of advice. Yes. And the immediate family member thing, how would that vary? Or would it be the same kind of grounds? And then
it's the same analysis. It's just my risk tolerance. I'm willing to go to prison if it means saving my daughter or wife's life, even if some prosecutor thinks that I was doing the wrong thing. It just comes from a risk tolerance standpoint. As if if my son or my wife or my mom, is getting pulverized by somebody, I'm going to jump in. I'm going to do what I need to do to save them. And if somebody wants to question that after the fact, then it's like, okay, I'll take whatever's coming. But I'm, the option of my family member not going home safe is just not an option. So, it's not a legal distinction. It's just a risk tolerance thing.
Yes.
So
absolutely. Are you in search of top-notch gear that exceeds your expectations? Look no further than GPS, brought to you by Go Outdoors Incorporated. GPS has been dedicated to crafting the finest products for hunting and shooting since 2002. As someone who frequents the gun range, my GPS bag is a staple to safely and effectively haul my gear. Their specialized bags are designed to keep all of my valuable equipment secure and organized. With GPS, you can experience the ultimate peace of mind. There are 3 exciting product lines: GPS Tactical, GPS Wild About Hunting, and GPS Wild About Shooting provide the perfect solution for your specific needs. So whether you're on a hunting expedition or hitting the range, GPS is your reliable companion. To choose a bag that fits your needs, use code SheetShield at checkout to save and to support the pod. That's SHESHIELD at checkout. This kind of reminds me, I'm not going to laugh, but your situation of the large male and the older lady, this has actually happened to me and I have intervened. At the time,
oh, wow.
I wasn't concealed carrying. This is a situation where I kind of realized I wanted to, even though I would not have used it in this situation. It was just one of those that made me think on a deeper level. I knew just enough about like hand-to-hand combat to get me in trouble. I was doing Muay Thai at the time and I actually felt like a machine. Like I felt very, I felt very sure of myself. Maybe not so much now with hand-to-hand, but at the time I was training for fights. So I was kind of like, come at me, Yeah. But I was leaving a dinner with my boyfriend at the time, and our cars had gotten the boots on them, the yellow boots, which if that's ever happened to you, it sucks. It's not cool. But also the person who did it is literally just doing their job. So, my boyfriend at the time, we had actually paid the dues in the parking lot because we knew, especially in this location, well, first legally, of course we would do that, but we also know that they will boot you the second they see your parking, out of means. So, we come out and it's booted, and he's kind of bummed because he had just gotten in a car accident I think a couple days before that. So he was like, oh man, just kind of sad. He wasn't mad at this woman. She's probably in her 60s, I would say. Definitely was very surprising to see her in the college bar city street booting cars. I didn't think that was very wise of whoever, stationed her there, but teach his own. And on the other side of our car was another car with 3 guys, all college age, not particularly buff, but also very tall, right? And they were cussing her out. And at some point they started moving into her. So I immediately started walking towards them and I cussed them out. And I could just I felt like I had veins bulging from my neck. And I told them to back up. My boyfriend at the time was in shock that I was doing that. So he literally stayed where he was, not with him anymore. So anyway, but, so I'm charging these guys, and I'm telling them get the F back, because at that point, I felt like we were past the point of hey guys, that's enough. You need to back up. Mm-hmm. I really felt like I didn't know anything about mucking, but my gut was telling me that I didn't have much time to de-escalate. So I told them to get back. And then the guy that was leading the shittiness, which they were all drunk, the guy that was doing that was like, "Oh man, I'm sorry, lady. Like, I'm real sorry," and like started backing up to his car. And I was like, "It's okay. Just stay where you are. Please don't get any closer to her. That's unnecessary. Let her do her job." Apparently the system had not updated. So she had booted like 4 cars. And there were a couple other people waiting by their cars. You know, my boyfriend was stuck in time. And I stood by the other 3 guys, and one of them started up again and started walking towards her. And I did the same thing. And I just remember thinking like, well, if something happened, if it escalated, I would have to like protect myself hand to hand in these heels and this mini skirt and these hoops in my ears. And I wouldn't have anything else. So, but like, I do think back to that situation, like what would have happened if they would have attacked her and then like someone maybe attacked me? I don't know. And then I used deadly force, and then the CCTV footage, I think that's the correct word, like the video footage of on the street, right? Collects that I had incorporated myself. How would that look? So, I mean, in a situation like that, what do you think would have happened?
Well, you've got several things in your favor in that situation. You've got both relative size disparity between the assailant and the victim, and you also have multiple attacker situation. So you've got 2 things that would lend itself to, you know, because the question would be, if you use deadly force. Now I'm just going to talk about deadly force, not non-deadly force, but you first have to make sure that the person that you're defending was not the initial aggressor and that the person who attacked them was in the wrong. And I think that would be fairly easy to show in this situation. You've got someone that's just angry about a ticket. And so there's, you know, it's pretty clear that the boot lady would be seen as a victim and that she had not instigated or started the altercation. And then you would need to be able to justify that you thought they were not just going to commit a simple battery or assault against her, but they were actually going to inflict serious bodily injury or great bodily harm. And so that's the part where, you know, you would have to really be able to go into detail about why you thought they weren't just going to stand there and scream at her and yell at her and maybe shove her, but you thought that it was reasonable to believe that it was going to go to the point of great bodily harm or serious bodily injury.
Interesting. Okay. So going back to one of your initial answers and kind of just troubleshooting it almost. Okay.
Exactly.
So that's what you said is interesting. The shoving part. So because she was older and like fall risk for older individuals can lead to like detrimental results, not just injury, but long-term stay in a hospital bed, which leads to like increased morbidity. So what about that portion of it and the age disparity? Is that something that would be taken into consideration?
Absolutely. Absolutely. Okay. And what I tell people is everything is taken into consideration. The humidity in the air, the sunlight, whether the pavement is wet, absolutely everything is taken into consideration. And at the end of the day, the charging decision is simply up to the prosecutor, and the conviction decision is up to the jury. So it's whether or not the jury, assuming you've been charged, assuming the jury decides, you know what, considering everything that happened, we think that it was objectively reasonable what she did. And so, yeah, but absolutely everything can be taken into consideration.
Absolutely. And just to be clear, looking back, I would have not, if I had my pistol, I would have not pulled it in that situation.
Yeah, that's good.
Because it was able to be de-escalated, and we stayed and watched as she took their boot off, and we let them go first. She was going to do our car first, and I was like, no, do theirs. Like, let's
that's smart.
So yeah, she was very thankful, but I could also tell she was a little in shock. Like she was very quiet. And yeah, I felt, because I mean, my mom was probably, at the time, like in her mid 50s. And like, I just immediately thought of like, boys, man. But anyway, not men, boys. Anyway,
that's right.
I'd love to switch gears a little bit. All that was incredible. I'm just, this perspective again, is just amazing. So when it comes to obtaining legal insurance for concealed carry, what would you have to say about what to consider when it comes to choosing a company?
Yeah, this is something that a lot of people look into, and it's a really great idea. And I would say that the number one thing people need to understand is that an insurance company cannot underwrite and cover criminal activity. And so as people hear that and they go, okay, well, yeah, that, of course, why are we even talking about that? The way this plays out is you have a policy. That policy covers all your legal fees, expert witnesses, consultants, whatnot. By the time you get to trial, you're probably $200,000 to $500,000 invested in your defense at that point. You're on trial for either second-degree murder or voluntary manslaughter, typically what the charges are in these kind of self-defense situations. Depending on the jurisdiction, you're looking at anywhere from 15 to 30 years in prison if convicted as charged. You believe you have a good argument. You believe that, you probably prevail with the jury, and either right before trial or towards the end of trial, the prosecutor pulls your attorney into the hallway and says, hey, look, we want to work this thing out. We want to do a last minute plea agreement. Have your client plead to some low level felony. Let's say, or even maybe a higher misdemeanor, negligent discharge of a firearm, or just aggravated battery, or, reckless homicide, or something in the jurisdiction that would be a probation sentence. And we'll agree to probation, and he or she will walk out of here not in handcuffs today, go home, and just be on probation for a year or two. Now, I don't know how many people have the cojones, if you will, to say, no way, I'm going to turn that down. I think the jury's going to come back with a not guilty. If you decide, you know what, it's in my best interest to go ahead and take this plea, an insurance policy will stick you with the bill for your defense. So you will be in a situation where you'll have to decide, I want to take this plea because I'm so risk averse. Look, guys, juries get it wrong all the time. Okay. It happens. I think juries get it right most of the time. I really do, based on personal experience, but juries get it wrong sometimes. And you are putting your faith in 12 people applying the law correctly and believing your version of the story or believing the argument that your attorney made. And so are you willing to risk 15 or 20 years of your life when you have a guarantee of just walking out? Yeah, you have a conviction on your record, but you don't spend a single day in prison. I can't speak for everyone, but I think a lot of people would go ahead and do the risk-averse thing and take the deal. And if you do that with an insurance policy, you're going to get stuck with the bill. Whereas some companies are not insurance policies. They're a self-funded legal protection plan. And basically what that means is the funds for your defense and the funds for everything come from the company itself, come from people's monthly or annual premiums. And there's a pool of money there. And when they need to use it, they do. Those companies, most of them will say, look, you do what's in your best interests. And if you need to take a plea, if you need to do whatever, that's fine. You'll still be covered. Whereas the insurance company, they purchase a policy from one of these bigger, like think of Lloyd's of London or whatever, these bigger insurance companies, which then will kick in when they need to. It's almost like buying a car insurance policy that has in the fine print, yeah, we'll cover you unless the accident was your fault. And then if we determine that the accident's your fault, you're on the hook for everything. Nobody would buy a policy like that. So
right.
I hope that answers the question.
But, absolutely, it does. Yeah. And we had a phone conversation before the episode, which I appreciated because it gave me a chance to think on this. And I actually talked to my fiance about it. We both have the same policy, signed us up for the little couples deal, and we did not know that. And
most people don't.
Right. Yeah. And well, instead of going into what, you're welcome to share why you think that is if you would like to. But I would also love to know if you have any recommendations on like policies that I mean, I know you mentioned one that you have currently.
Yeah. So I know that CCW Safe is a non-insurance policy. I don't have any affiliation with that company. I don't get any sort of referral or whatever. As much as I promote them, you'd think they would give me an endorsement policy, but no, I'm just kidding. But or a sponsorship. But no, it's an organization that I think does a good job. They've got really good attorneys on staff, and that was a specific question that I had when I was researching this topic for some friends, and that's when I learned about this. I mean, I've been a lawyer for over 10 years, and it was literally maybe a year ago that I really understood the difference between a self-funded legal protection plan and an insurance policy.
Wonderful. Yeah, that's good to know. So USCCA is a pretty popular one, and I actually I'm building up to being a partner with them with firearms instruction. So this is great. First of all, I just want to say you have helped so many people by telling me that, because I will then relay this to anyone I teach. And while I think USCCA's policies for they are an insurance company, I think is what we discussed.
I believe so. Yeah.
Okay. While that's fine and dandy, personally, I'm going to look into concealed carry safe. So, right? Sorry, CCW safe. Right?
Yeah, CCW safe.
Okay. That's what I wrote down. And then I was like, wait, is that right? Doubted myself there for a sec. But yeah, so I'm personally going to look into that as well. And I don't see that as a sacrifice. I see it as an investment, because I just can't imagine. And what's interesting is now that I've actually trained the 0 to 5 foot range and, truly been in situations where someone has been larger than me and, given enough top pressure where I was just squished under them, like an insect. I don't ever want to be in a fight. And
that's right.
I truly, truly don't. If I ever have to, it is so obviously going to be because I did not feel like there was any other way, or I have to protect my sisters or mother. I will say my middle sister, my whole life has been, now she's a lot better, but she's so kind when strangers would approach us, even though at the time we were oh my gosh, 16, 17, walking alone somewhere. We should have not been stopped by a group of men.
That's right.
And she, she'll stop and talk to them. They asked her about her car, and they were kind of circling the car. And I remember being something's not right. Something's not right. And she was yeah, it's a 2000, 9 Tahoe. And she's my dad got it for me. And I was yep. And I just grabbed her and then put her elbow under my arm and shoved her, with me forward out of the situation. But yeah, even then I knew I didn't want to get in a fight. But now that I know how bad it can get, it just from even a simulated controlled place, I don't want to get in a situation. So
that's a great perspective. Yeah.
Really great to know the preventive side, at least of the legal side. So thank you for that. I'm curious as to your past. Did your self-defense training come before law school or after?
After.
Yeah, okay.
After. Yeah. I graduated law school in 2010. I had a concealed carry permit, pretty much since I was 21, but I was just that guy who would just go to the range now and then and, never did any other training. I got into Brazilian Jiu-Jitsu in 2011, wanted to learn to protect myself, just kind of go from there. And then it was, 2016, 17, I was doing some shooting classes, and someone there was hey, have you ever heard of this guy named Craig Douglas that sort of incorporates jiu-jitsu into shooting? And I was wow, that sounds amazing. How do you incorporate grappling with shooting? And so that's when I kind of started to look into the videos and learn about entangled gunfights and stuff. And that really piqued my interest. And then I was lucky enough to get the school that I was at. Ben Aubin of Redbeard actually happened to be one of the black belts at that school. So I got plugged in with him and started doing some combative training with him. But it kind of all, the law school, the legal career, and the self-defense combative stuff kind of all happened in tandem at the same time.
Wonderful. That's good to know. Did you feel at any point that you, did any cases give you a feeling of kind of encouragement to go get more training, trying to put it in a light way? Did any cases
Not, not one particular case, but I think what I saw overall was, man, if these people, these defendants or whoever, had the ability to very cogently and coherently articulate why they did what they did, I think they would have been in a much better situation. So I definitely saw that theme throughout.
Yeah, that makes a lot of sense. And I'm sure, do you mean kind of like understanding the legal side as well as the self-defense side? Because I feel like one without the other is...
Yeah, even if you don't know the legal side, well, number one, I would say if people didn't talk as much, there wouldn't be as many convictions. So I can't tell you how many times I have told my client, yeah, well, if you had shut your mouth, I'd be able to walk you out of this courtroom right now, but you had to say something. You had to talk. And so that conversation has happened a ton. But number one, not talking as much. And then if you're going to talk, like we kind of mentioned with the muck scenario, like being able to articulate just the facts of why what you did was reasonable and why there was no other alternatives to what you did.
Yes, absolutely. And when it comes to, speaking of talking, when it comes to a situation where you've had to defend yourself in any situation, hand, even all the way up to gun, kind of like, force continuum, just utilizing that a little bit here, the little I know about it. What would you say is the best thing to say to like dispatch when you call and when police arrive? And what would like a perfect scenario be if you had to, let's say like worst case scenario, use your gun, you still have the pistol, it's still live, and the cops are on their way? Yeah.
Well, I'd say from a safety standpoint, definitely don't have a handgun in your hand when police arrive on scene. So if the situation has been neutralized, I would holster up, keep your hands where people can see them and everything, raise your hands when, that's just from a safety standpoint. I will say there's actually a split of authority in the legal community about how to best handle talking to the police after an event. And really, there's two schools of thought. The one school of thought is don't say anything at all and just, call your lawyer. Don't say anything at all without your lawyer being present. The other school of thought says give a very brief synopsis of what happened, but don't go into any details. And what I would say is when you're deciding what to do, if you decide that you want to say something, rehearse. I don't want to say rehearse because you can't rehearse because the facts are very unique, but say something like, I was pumping gas. This guy attacked me with what appeared to be a knife. I was in fear for my life and I shot him and defended myself. That's it. Don't go into any more detail. Or this guy came in, he's tried to rob the store. He pulled out a gun. I was in fear that myself or somebody else was going to get killed. And so I shot him. Very brief synopsis of what's happening and rehearse what you say next. Something to the effect of, I'm going to absolutely cooperate, but I have been counseled or I've been advised to not make any thorough statements for at least 48 to 72 hours after the event. And remember that police officers are trained to do this exact same thing when they're involved in an officer-involved shooting. The police unions don't want them to talk unless they've had at least 1 or 2 nights sleep and at least 2 or 3 good meals in their belly. And 48 to 72 hours later is when they'll issue a statement about what happened. And that's because of the ocular occlusion, the task fixation that happens in a deadly force encounter. A lot of tangential facts, observations, circumstances are not really processed by you. And you don't really have a clear, holistic view of what happened right after something happened. And just remember, too, for the people that say, well, I'm not going to say anything at all. Well, when you call the dispatcher, you're saying something to them. And that's recorded and everything. So don't think if you call the dispatcher and say, guy with the green shirt came around the corner and I blah, 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 and I shot him and then I did this and then I shot him in the leg and then whatever. And then the cops get there and you're like, I don't want to say anything. Well, okay, well, you've already made a statement because you were talking to dispatch. So just kind of keep that in mind. But I don't want to tell people exactly what to do, but just understand that You don't have to say anything. It is the police job to try to get you to talk. So understand that they're going to try to get you to talk and say something, and they're not doing that maliciously or trying to be a bad guy or anything. That's their job. But you need to be comfortable saying, sir, ma'am, I'm absolutely going to cooperate. I'm absolutely going to make a statement, but I have been advised to not make any statements, 2 or 3 days after the incident. And I would like to speak with my lawyer first.
So follow up to that, how would you ever be concerned that would be seen as kind of like preemptive I'm looking for a word, premeditated, like bodily injury or deadly force to somebody else? If you were to say, I've been advised, like if someone doesn't know that
Right.
you have been like training in concealed carry, like you've been an advocate for your self-protection.
Yeah.
Could that be seen badly?
Number one, by the police officers, the police officers should know enough to know that that's a good practice because they've been trained to do the same thing in an officer-involved shooting. From the jury standpoint, the jury should never hear that because your lawyer should argue that your right to remain silent is a constitutionally protected right, and that should never, that should be inadmissible in front of the jury. Because essentially what you're doing is exercising your Fifth Amendment right against self-incrimination, and that is a person exercising a constitutional right is never something that a jury should be allowed to hear.
Okay, that's good to know. That makes a lot of sense. Yeah, I've worried about that in the past, just with my training. I get a lot of comments too, and I think this is why I've worried about it on social media. And don't worry, I don't let them be the reason I make any decisions. But of course, it's crept in the back of my mind, right? I get, especially on TikTok, where I'm on both sides. Like just the other day, I finally made a post where I finally have people who like get concealed carry. Whereas like I've gotten terrible comments in the past. Like the other day I got like, oh, heading up to shoot up some school, and then one guy, or not even one guy, the most common comment I get is like, you are the most paranoid person I've ever seen. Like, why are you so paranoid? So yeah, if like a jury member, I would think, sees concealed carry as paranoid, that would suck for my case. Is there a screening process in these situations where they ask the jury, like, does anyone have any bias against concealed carry or anything like that?
Yeah, that's definitely part of what's called voir dire, depending on what part of the country you're from. Okay. And that's the jury selection part. And they ask different questions. In most states, the attorneys get to perform the jury selection. In some states, the judge asks the questions, but in most states, the attorneys are allowed to ask questions. And that's absolutely something that I would ask in that kind of case is, do you have a problem? The way I would pose it is, do you have an issue with someone exercising their Second Amendment right to carry firearms? Do you have a problem with that? And then if so, figure out who has the problem with that. Why do they have a problem with it? And get them the heck off the jury. You have certain preemptive challenges, which means you have the right to strike someone not for cause, as long as you're not striking them for race or gender. And if I've got people on the jury that seem to be anti-Second Amendment or anti-self-defense, I'm getting them off the jury. And arguably, I think I could have a challenge for cause, even if I ran out of my preemptive challenges. So yeah, but no, that's a great question. There absolutely is a screening process, and you're not always going to get everybody off the jury that you want, but you can definitely get that one or two people that just seem to be like, I don't know why people carry guns, and I think someone that carries a gun is looking for trouble. All right, yeah, they're off. They're out of there.
Yes. That would be like 5% of whoever lands on my videos at any time. So yes, a little dose of just BS every day. Yes, absolutely. Thank you for sharing that.
Sure.
Could we kind of switch over to home defense a little bit?
Absolutely.
So how would home defense change when it comes to like state laws someone needs to be aware of? I know in Arkansas we have pretty recently Stand Your Ground. We also have the Castle Doctrine provision. So how, like, if someone wanting to know how to kind of have a home defense plan, what should they know about their state?
That's a really good question. So you've mentioned two terms that I'll define for your viewers, just so that they have clarity. Stand your ground. One of the things that I see on these videos and comment sections, everything, is some people think stand your ground means I get to shoot somebody if they put their hands on me. Stand your ground does not change the threshold for deadly force. It simply means you don't have a duty to retreat prior to meeting force with force. And so that's stand your ground. The Castle Doctrine is a combination of stand your ground in your home, as well as typically what's called a presumption. Presumption is, in my opinion, one of the least understood terms in self-defense. It's also one of the things I'm going to spend a lot of time on at the summit, because I think it's very, very important for people to understand. But a presumption, best way to explain it is typically you have to prove or articulate that you were in fear of death or serious bodily injury before using deadly force. I mean, we've talked about that at length. In certain situations, the law will presume or assume that you were in fear, you were in reasonable fear of death or serious bodily injury. The most common situation is in the Castle Doctrine, where somebody forcibly enters your home that does not have permission to be there. And so they unlawfully and forcibly enter your home. And so both of those things have to be present. Unlawfully enter your home, so they can't be someone that has a right to be there, but you just changed the locks, and so now they're kicking in the door. And we can kind of talk about that situation if you want to later. But also that they forcibly entered the home. So not just that you left the door open and they just walked in. That's just a simple trespass. But if someone is unlawfully and forcibly entering, breaking a window, kicking in a door, I mean, even I forcibly, opening a lock with like a lock picking kind of thing and getting in there, the law is going to presume that you are in fear of death or serious bodily injury. So what I mean is, you hear your door kicked in at night. You grab your gun. You go down the hallway. You see a person in a hoodie walking towards you. You shoot them. That's going to be justifiable. Okay? Because you had a presumption that you were in fear of death or serious bodily injury because that person did not have permission to be there and they forcibly entered your home. Now, for educational purposes, I want you to imagine that you try to say, I was at Walmart and a guy with a hoodie was walking towards me, so I shot him. Well, you're going to prison, right? What's the difference? Factually, what's the difference between those two scenarios? One situation, you have a presumption of fear, and the other, you don't. So in the other situation, you have to articulate, well, why did that guy in a hoodie walking towards you, why were you in fear of death or serious bodily injury? You don't have to be able to articulate that when the person has kicked in your door in your home and is walking towards you. So that's really the application of the presumption of fear that you have in your home. And that's really the essence of the Castle Doctrine.
Thank you for explaining that.
Yeah.
I knew some of that, but not all of it. So embarrassingly so, but
I also want to mention, these are rebuttable presumptions. So what that means is someone's in your home or someone breaks in your home, but it immediately becomes apparent to you that they're not a threat to you. You're not allowed to shoot them anyway. And so the situation that I give, and it's kind of crazy, but I hope people see that is somebody breaks into your home, you go in the room, the lights are on, and you see an adolescent, naked kid with obvious Down syndrome. Why do I say naked? I say naked because you know that they can't have any weapons on them. You also live a block or two from a special needs home or whatever. You walk in, you see some kid in his undies or whatever, he's got Down syndrome. It needs to be apparent to you at that point that this was some type of horrible mistake and some type of horrible thing. The fact that someone is in your home does not just give you this blanket license to kill them. What it does is it gives you the benefit of the doubt when you do act in self-defense. So same kind of thing. If a person is breaks into your home, you come in and they are running towards the front door. And as they're in the front door and as they're about to leave the front door, you go ahead and start popping rounds off or whatever. You might have an issue in that situation, because at the moment you shot them, the state might be able to rebut your presumption of reasonable fear, because if it was apparent to you that they were in the process of running out of the front door and they had actually made it to the front door. Now, I also want to rebut the myth that people say, oh, well, you're not allowed to shoot somebody in the back. If you shoot somebody in the back, you're going to prison. That's not true. Somebody turns away from me in my home, they've broken and they're running down the hallway towards my kid's room. I'm lighting them up. I'm still lighting them up. And I don't care that I shoot them in the back, because at that point in time, you can't rebut the presumption that I was in fear of my children's life, or that a violent, forcible felony, either rape or kidnapping, would be done against one of my kids, because they weren't running to the front door. They had not made it to the front door. They were running to another part of the house. Maybe they were going into the kitchen and I have knives in the kitchen, or maybe they turned and their hands disappeared and I don't see their hands anymore and I shoot them. All of those situations, you're still going to have a really, really good argument for self-defense. So I'm not trying to ramble, Sophia, but,
amazing.
But what I'm trying to say is people like to come up with a if A, then B situation in the law. Well, if this fact is present, you are justified, or if this fact is present, you're not justified. And that's almost never the case. It's certainly a fact that will be considered, but it always comes back down to that same analysis.
No, that wasn't a ramble at all. I was helping you. I felt like that was needed, because it's not black and white. So
yeah, absolutely.
I appreciate that, actually.
Sure.
And I actually just went from living in a 450 square foot loft to now I think it's 1,400 square feet. So just like way, bigger than before. So my means of self-defense have changed. My weapon of choice has changed. I don't have immediate neighbors now. And I also have like several floors to my house. So I have new things to consider. But yeah, no, that's good to know. And as far as the means to self-defense, so the type of gun use, so like say I fired off a 9mm as opposed to like an AR round, like a 223 5.56, would that ever be looked at differently in the eyes of the law? Okay. No.
Deadly force is deadly force.
Gotcha. Okay.
So, yeah. I tell people, if you're not justified in shooting them with an AK-47, you're not justified in shooting them with a 22. So it's all the same.
That's a great point. Okay. Yeah. And I've even thought about getting a pepper spray canister. Sabre sells this, like home defense pepper spray canister. I've thought about getting that for the front porch, not front porch, sorry, my front door. Like just on the like rare occasion that like someone, I don't know, maybe there was a storm, like last night there was a storm and one of our chairs blew in the yard of our neighbor. And he's so funny. He sent us a picture and he was like, I have your chair hostage. And he was like holding the chair. It was so funny. But say like we had really awful neighbors and they came over and picked a fight with me and maybe tried to like step into my house. Like I don't know, maybe it's some like short mom that's just like doesn't have weapons on her. I would want to just shoot her, but I might want to like pepper spray her. Like, what would you say about having like multiple means of self-defense for a household for a weird situation like that?
Yeah, no, that's great. I mean, pepper spray is not considered deadly force. So that would be an appropriate choice in the situation that you just described, and that's a really great perspective that you have. And I'm really encouraged and impressed that you have the perspective that there might be a situation where you could technically shoot somebody, maybe because they've crossed that threshold, but you have the discernment and the wisdom to know that in that situation, it probably wouldn't be the smart thing to do. So I'm really encouraged that your viewers are probably getting some really, really good advice and good perspective from you and everything. But no, I think having multiple tools is great. It just gives you different options. So no, I think that's fantastic.
I appreciate that. Thank you. Yeah. And yes, I'm trying to get away from the comments that I get, which I think they're trying to be supportive, but I disagree with them. And it's like, the solution is pew pew, or like something like that. Like I get that comment all the time and I'm like, nah, dude, it's not though, because I make a joke sometimes like to people like that. And I'll say something like, I don't want that on my record, but also don't want that on my mind and my heart. And
that's right.
That person and their family, like it's just so multifaceted. Like the second I entered the gun industry and like my first issue was like trying not to print, like I've just learned so much since then. There's just so much to it. So, and that's what this podcast is for. It's to debunk some things. It's also to talk about things that don't get enough attention, in my opinion. Like even the other day, I had a friend come on and we read some of like the creepy, funny, like just hateful comments we get on social media. And we made it a conversation about social media and the gun industry and the gun community. And so yeah, I really appreciate you saying that. Thank you so much.
And people forget that what they put on social media is discoverable. So I have, over the last few years and kind of being in this space and putting things on the internet and everything, I've become a lot more cognizant of that. But what you type in social media, the comments, even what you text to people, there was a case, I don't know if you heard of it, but the case out of, I want to say it was Austin recently, a guy was convicted, and I truly believe it was based almost entirely on his online comments and his texts that he sent to a friend is what got him convicted, because it showed that he was looking for a problem. He ended up shooting a protester in Austin. And although the facts on their surface, I think probably would have led to a not guilty verdict, some of the texts that he sent and social media posts showed that he was probably going to this situation looking for a problem. And so I've done a video on this before too, where like, I hate when people wear t-shirts like, I don't call the police, I reload, and stuff like that. And it's kind of like, okay, what if you're wearing that t-shirt when you happen to shoot somebody, you know, like what,
right.
You know, or people, you're going to get arrested. The first thing they're going to do, they're going to get a subpoena, start going through your social media feeds. And, you know, they find a post of, hey, I've got a beautiful daughter. So if anybody breaks her heart, they're going to find your body in the woods and stuff. And it's like, okay, like that's all fun and games. And, you know, hopefully your friends know that you're joking, but a jury doesn't know you. A jury doesn't know that that's not how you actually think. So, yeah.
Oh my gosh, that's so true. And I saw on TikTok the other day, I think I've already said this on an episode, but it hasn't been released yet, that you can technically look up someone's username on TikTok. And I haven't tested this, so just disclaimer there, and find all the comments they've made.
Ooh.
And yeah, so like what's crazy is the only time I leave negative comments is when like there is someone in the comment section. It's usually on something self-defense. I try not to like go outside of my niche there because especially once I learned this, but when someone says something just so blatantly wrong, like the guy commented on my ECQC video, and I'll go and say something like, hey, like this thinking is problematic, you know, you need to consider the following things, something to like help them think. Or I'll just be like, I've even just said like, shame on you to a few people, things like that. But you know, because when my mom says that, I'm like, you know, but if my mom were to be like, you know, say something like, I don't know, cuss me out, I would be as offended probably if she was like, I'm disappointed.
I'm disappointed,
so, like,
right? That's right.
So like, I'll comment that on some people's stuff. Right. But I've even told a friend before, like, you should totally look up this guy before you go on a date with him. Like, look at what he said on videos, like if he's shaming women's bodies, I don't know.
That's a great point.
But it's all out there forever. And like, I think my first run-in with that was in junior high. Someone on my basketball team got in a Facebook fight, and Facebook was the only thing around. Instagram was fairly new, like it just come out. And they were fighting over some boy. It was stupid. And I remember like going to war for a second on Facebook, and my mom was like, do not do that. The internet is forever. And that was the first time I had to think about that. And, you know, because I felt like I was standing up for my friend, because she was the one being kind of badgered, and I'd been with her, like we hung out every day. So I knew she wasn't with this boy. So I was going to be like, you know, and mom was like, don't do that. Like, she was like, I can already see where this is going, you know, and I mentioned she's an attorney. So
that's right.
I'm really thankful for her. And that's such a good point. Like that's thinking on the other side, like putting your trying to be in the shoes of the prosecutor, if they're just doing their job, trying to defend, their person. There's probably a word for that.
That's okay.
But yeah. So yeah, that's lovely. That's good to know. Yeah. Wonderful. Well, I guess the last thing I want to make sure we talk about, kind of like getting the full 360 view, is vehicle carry. Is there anything you would like to say about carrying in your vehicle, or like leaving a gun in a vehicle? I know there are, like, state laws vary, but yeah,
no, I would just say that that's an area that is extremely state specific. And states can be really finicky about how you carry in a car. So there are some states where if you've got a concealed carry permit, you can have the gun wherever you want. There are some states where even if you have a concealed carry permit, they want it to be either center console, glove compartment, or on you. And and so it runs the full gamut. So, but I will say that, like I said, some states can be so finicky. And when you read the statute, you're like, wow, it's that specific. So just reference your state, understand, what you're allowed to do, and make sure that you, if you're pulled over, you do identify yourself as a concealed carry person. You have a gun. Let the officer know. Don't reach for it. Don't show it to them. Don't, have it anywhere weird or whatever, but just, and let that be. And I've been pulled over before. So I've gone through this process. You keep your hands at 10 and 2, and literally the first thing you do is just say, I have this is my driver's license. I also have a concealed carry permit, and I do have a firearm in the center console or in the glove compartment, or I'm appendix carrying it right now. And so, I'm not going to touch it or whatever. If you want me to produce it, please let me know. I'll comply with whatever request that you have or whatever, just to put the guy, the officer, male or female, at ease. But about carrying it, definitely know your state law on that.
Absolutely. Thank you. And my question wasn't for you to go through all 50 states and give every, law what I wanted. And you did exactly that, is spur some curiosity in the listener to look into your state laws, if you haven't already. And
they can be surprising. Like I didn't realize in some states putting the gun on the floorboard is against the law. And so you might just not have look that up, and you're the kind of person, for better or worse or whatever, you just stick your gun under the driver's side seat or on the floorboard or whatever. And, you tell the officer, I got a gun, it's on the floorboard. And he's like, well, you're not supposed to carry it, so I got to give you a ticket for improper handling of a firearm and stuff. So, I just hate to see people get in trouble that are well-intentioned and are like trying to do the right thing, but it's just a simple ignorance thing. And I don't mean ignorance in a disparaging way, but just honestly not knowing. So, yeah.
Yes, that's how I meant it as well earlier. It's a great word to utilize in this space, because absolutely. Totally agree with you. And as far as presenting, as you mentioned, a concealed carry license, what is the benefit of having that compared to, in a situation specifically where you would have to use your gun for self-defense, compared to someone who doesn't have it and they're just in like a constitutional carry state, like Arkansas?
That's a really good question. As far as dealing with law enforcement, I think it helps because it immediately lets the law enforcement officer know that you're not a convicted felon. And it lets them know that you don't have any outstanding warrants or domestic violence convictions or whatever. And I've talked to, in the space that you and I are in, we meet a lot of law enforcement people, have a lot of conversations. And the thing that I hear over and over again is when they find out the person has a concealed carry permit, it does tend to actually put them at ease. It doesn't heighten their, stress or whatever. It actually lowers it. So I think it's a good thing. As far as, is it going to help you at a trial? I don't think it hurts you. I think a prosecutor, an unethical prosecutor, could try to make it look like, this person has a concealed carry permit. They're running around thinking they're a cop, but look, any good defense attorney is going to be able to squash that really, really easily. So if you hear people say, well, a prosecutor is just going to say blah, 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 blah. Okay, look, a prosecutor can say whatever they want, but if it's intellectually disingenuous, it's going to come back to bite them. So I wouldn't get too concerned or worked up if you hear, oh, well, what if the prosecutor says that the fact that I drive a Chevy, it means that I want all Asian people to die. It's like, okay, well, they can say that, but it's like there's no truth to, there's no veracity to that. So I wouldn't get too overly concerned with theoretically what someone could say if it's intellectually disingenuous.
Absolutely. That makes a lot of sense. And I love that because I feel like that just automatically shuts down the comment warriors, the screen warriors that say like, what if and what if, right?
Yeah. I've heard people say, oh, I would never carry hollow points because it shows an intent to kill. And it's just like, oh my gosh, like that's like, and then I have to go on a rant. I don't like to do rants anymore on social media, but if I hear something that's stupid, you go on a rant. It's like, okay, if a prosecutor says that or tries to argue that, that's fine. But a good defense attorney that's well versed in self-defense is going to stand up when it's their turn to talk and point out how incredibly stupid that is.
Absolutely. And I feel like it discredits them as well. Like it's almost not in their favor,
Absolutely. I would think. 100%.
Right.
No, 100%.
Awesome. Yeah, that's good to know. Absolutely. Oh my gosh. This has been such an interesting episode. I've just learned so much.
I'm glad.
I've pretty much asked all the questions that I've wanted to. Is there anything you would like to share with the listeners before we end the episode? Is there anything that we didn't cover that you would like to cover?
The only thing that I want to mention, and you feel free to cut it if you think it doesn't fit in or whatever, but we kind of mentioned that in the importance when we were talking on the phone of people getting the domestic violence protection order in place. And so I would encourage people, if you feel threatened by someone, whether it be a male, female, whatever, and you feel like your safety is at risk, go out and get that protection order. I know it might create problems in the relationship, in the family or whatever, but I would just counsel you that, or tell you, because it's not legal advice, like I said before, so I can't counsel anybody, but
right.
I would just say my perspective on it is when that person decided to threaten you or hurt you or whatever, they're the ones who put the relationship at risk. And so you going to get the protection order is not what's going to cause this relationship to break down. And God forbid something escalates to a point that you find yourself in court, either as a defendant or as a testifying witness. If you try to say there was this long list of things that happened leading up to this, and the other attorney gets up there and says, okay, there's no police report to verify that any of that happened, right? And you have to go, no, and you never reported that to the police. You never did this, that, or the other. No, I never did that. It's going to make it harder for your side of the story to be told and believed by a jury. So not to suggest, not to ever victim blame or victim shame or anything like that, but I'm trying to give just the nuts and bolts of the reality of how trials work, because look, I have been that defense attorney that has had to try to discredit witnesses before. And that's the kind of thing that I would do. I mean, I don't feel bad for that. I was just doing my job. But I want to give anybody the benefit of understanding, like, look, document what happened. And the last thing I'll say about that is that we kind of touched on that presumption of fear in the home. And if you remember what I mentioned was the person has to be illegally coming into the home. All right. Well, if that person if you kick your husband out or your fiance or whoever, and I'm going to stick with spouse because they're going to be always legally allowed to live in the marital home. If you go and change the locks because he was beating the crap out of you or whatever, and you kick him out and you change the locks, well, if no legal action is taken, he has every right to come back into that home. And if he kicks in the door, he's allowed to kick in the door of his own home to get back into his home. And so you can't be standing there on the other side of the door with a shotgun and then shoot him when he kicks in that door to his home when there is the absence of a protection order in place. Now, if there's a protection order in place and that protection order covers the home, which 99 times out of 100 it does, he doesn't have a legal right to come back to that home. And you do get to treat him as an intruder. So that's that's all I really want to say about the legal significance of having a protection order in place. Is in that type of unique situation, it can affect how you're allowed to deal with that person that's trying to forcibly enter the home.
I am so glad you talked about that. Yes, yeah. I actually completely forgot to ask you about
that's okay.
that. So
yeah, that's fine.
I'm glad you mentioned that. I actually know just a few women off the top of my head that have been in a situation where they've been pointed in on a door, you know, in their own home. And I don't know the specifics of that. Just hearing it, of course, I'm like, yeah, like she had a right to, knowing the past abuse, but legally in a court that looks different. So yes, thank you for bringing that up. And this also applies from my limited knowledge of the law. This also applies to anyone who's dealing with like harassment or stalking. Like starting a paper trail of any sort is beneficial. Is that something you'd like to speak on or elaborate on?
I mean, that's absolutely true. I agree. And it's just, you know, for the exact same reason that I mentioned before.
Absolutely. Yes. And yes, it's extremely, it's an extremely vulnerable process. I've been with friends through it. I've had to do it myself. And, while it's really scary to like do it, it does give you some peace of mind that if you did have to defend yourself, you would be within your rights, even more so than if you had not started that paper trail. So, just thinking critically through a perspective. I always think of have you seen National Treasure with Nicolas Cage?
Yes. Yeah.
Okay. So when he gets those glasses that have multiple lenses and you have to like overlap them to get the different colors. So this is really cheesy, but I saw that movie and I was like, oh, they're like perspectacles. Like you add lenses and then you have like this different perspective. So I feel like one of the lenses, you could argue what order, but at least one of the lenses, if you haven't seen that movie, it's just multiple lenses on a pair of glasses. So imagine that, should be the law lens. And, you will ultimately feel better at the end of the day. And it takes a little bit of time to learn, but luckily you listened to this episode today. Right. So absolutely. Well, this has been a game-changing episode, Chet. Thank you so much for coming on. Is there anything else you would like to share or you want to send the listeners off with?
No, just if you find this interesting, my channel on YouTube is The Combative Lawyer. I try to keep those videos always below 10 minutes. So it's a very single topic, anywhere from 4 to 9 minutes is what I shoot for. I don't really do a lot of entertaining. It's more informing. So it's pretty low production quality, but it's just me kind of hitting on a topic. And I try to take a complex topic and discuss it, or current events that are going on, cases that are happening in the self-defense world. So yeah, if you're interested, that's there. And just hope people do what they can and train and learn in self-defense law, just like they do on the physical, tactical side of it.
Absolutely. And do you have any jiu-jitsu or combative training goals for the next year or few years?
I mean, I'd like in the next year and a half, I'd love to get my brown belt in jiu-jitsu. So that's kind of what I'm shooting for. I mean, if it doesn't happen, it doesn't happen. But no, this year has been great. I've been able to train a lot this past year. I try to get about 4 or 5 times a week and, cross train in some MMA and kickboxing. But I think hopefully just leveling up in BJJ and then, maybe doing some brown belt tournaments once that happens.
Yes. Good for you. Good luck with that.
Oh, thank you.
I feel like that's a good time range because you never know like what's going to happen and you never know how much you're going to be able to get in the gym. So it sounds like you have a really good like reference, coming from a blue belt. So one who took some time, some great time off after getting her blue belt. So anyway, good luck with that. I'm excited to watch your journey. And yes, all of your social media information will be linked in the show notes. So if you're listening and you want more and you want to keep up with Chet and his informational videos, scroll down and you will be able to access those. And then for exclusive video content with guest speakers, you can become a Patreon. You'll receive a thank you note and podcast stickers and more exclusive content. You can visit the She Shield Instagram and TikTok at She Shield Pod. And then a special thank you to Sagetta Gear, one of the official sponsors of She Shield. For concealed carry gear and duty gear, you can use code SheShield10 for 10% off your Sagetta Gear order. All resources mentioned will be linked in the show notes, as well as the link for the Combatives Association Summit if you are interested. I already got my spot, so you're welcome now. I'm just kidding. And then if you like the pod, you can help by liking, subscribing, and leaving a review. Lastly, and most importantly, if you know anyone or you yourself are a firearms owner experiencing a crisis, look into holdmyguns.org. They are an organization that will connect you with a local gun shop or FFL to store your firearm for you, or even just a very pivotal component of the firearm that makes your firearm inert. The link to access their website and to find a storage location or partner is available in the show notes. Thank you so much, Tep, for coming on. This has been
thank you for having me.
Incredible episode. Yes, thank you. And in the meantime, listeners, stay safe and stay vigilant. Are you searching for a brand you can trust when it comes to shooting and gun care products? Look no further than Birchwood Casey. Since 1948, serious shooters, avid collectors, and professional gunsmiths have relied on Birchwood Casey. They've been in the game for over 70 years, providing us with products that have stood the test of time. From their legendary True Oil gunstock finish to the dependable Perma Blue, Birchwood Casey's commitment to quality is unmatched. Birchwood Casey has also revolutionized the way we train and improve our shooting skills with their innovative Shoot NC targets. These targets let you see your shots instantly, making it easier than ever to track your progress and become a better marksman. Head over to birchwoodcasey.com today and discover the products that have earned the trust of shooters worldwide. Use code SheShield to save and to support the podcast. That's SHESHIELD at checkout.